Testing, testing. Okay, so we're on the record for case number 9655. So let me take appearances first.
My name's Kim Curry, Associate General Counsel, representing Pepco. Can you hear me now?
Yeah.
Is this better?
Is this one? That one's working.
Kim Curry, Associate General Counsel, representing Pepco. I'd also like to enter the appearances of Matt Seegers, Doug Mikeel, and Taylor Beckham on behalf of Pepco as well.
Good morning, Your Honor. I'm Fran Francis, appearing on behalf of the Apartment and Office Building Association. I would also like to enter the appearance of Catalin Peter.
Good morning, Mr. Chairman. Jacob Auslander on behalf of the Maryland Office of People's Counsel. And also with me today is Michael Sammartino from the Office of People's Counsel.
Good morning, Mr. Chair, Commissioners. Lloyd Spivak for the staff of the Maryland Public Service Commission. I would also like to enter the appearances of Michael Dean, Annette Garofalo, and Kenneth Albert.
Good morning, Mr. Chair and Commissioners. James McGee on behalf of Prince George's County, Maryland.
And anybody else in the room? All right. Okay, before we turn to the company, we do have a housekeeping matter, and let me turn to Commissioner Barvey to articulate the specific concern.
Right. So the commission issued an order to people testifying before us that they should break up their testimony by person so that we don't have to search through a gigantic 800-page document. I understand that our staff actually spent a great deal of time breaking up the Pepco document. It was a commission order, and in the future I would hope that you would do that, since it's easier for you to do, and since it assures us that your testimony is properly categorized under the individual witnesses, so that no mistakes can be made. So if for the next time you do that, I think we'd all appreciate it. Thank you, Mr. Chairman.
Okay. And with that, go ahead.
I will defer to staff on the preliminary matters. I'm happy to start. There was one preliminary matter involving waiver of witnesses and doing live rejoinder. I'm happy to start that, or I can defer to staff to start it.
I think since the issues are yours, Counsel, it would probably be better if you would go ahead and get the ball rolling on those issues.
Great, I can do that. So the company had intended to do live rejoinder because it's a common practice, which makes sense because we have the burden of proof and we should have the last word. Staff filed the order of witnesses on March 3rd, and in that letter, staff mentions that AOPA objected to us providing live rejoinder on the grounds that Pepco has filed surrebuttal, and normally you do not allow surrebuttal, or you do not allow live rejoinder when there's surrebuttal. I looked and I was surprised to see that statement in there because that has not been the practice. There have been, looking at my research going back 9 years, 5 past rate cases, the company has filed surrebuttal and done live rejoinder, so I was unsure why the parties were objecting to the company doing what's very much a common, long-standing occurrence. In fact, most recently we did live rejoinder about a year ago in case number 9702, Pepco's second rate case, with all the same parties here. There was no objection. The rate case before that and the 3 historic test years before that, we also performed a live rejoinder. So the representation in the letter that does not occur, it just has not, that is not proven true in the research I've done. And another reason we'd like to do live rejoinder is that it completes the record. It provides transparency. The parties have asked us for transparency, and this is our opportunity to respond to the surrebuttal that's on file that we have not seen yet. The surrebuttal was filed at the same time we filed our surrebuttal. Our live rejoinder would be limited to that surrebuttal. And if the parties are concerned about time, the live rejoinder is typically brief. And AOBA had asked for an additional day for this proceeding, which was added, so we do have additional time. And I'd just like to close with a final statement. We've come to rely on doing live rejoinder. It's part of our strategy, and that's impaired if we don't have the opportunity to conduct live rejoinder, particularly if it's an objection raised 2 days before the hearing. That really does impair our ability to really defend our case.
I would like to respond to just one aspect of that, and that is that I don't have the benefit of whatever research that Ms. Curry did on the subject, but in my recollection, it is highly unusual for a company to both file surrebuttal testimony and do live rejoinder. Surrebuttal is supposed to be the last written word in the case. Live rejoinder is the last word when the other parties have filed surrebuttal, and the company needs to respond because, yes, they do have the burden of proof. So it may happen on occasion, but it is not in any way, shape, or form a normal practice.
Well, actually, I'll come back to you, but let me hear from everybody else first. So, no, go ahead.
May I, Your Honor?
Sure.
Okay. Your Honor, only 3 parties filed rebuttal testimony in this case: Pepco, AOBA, and OPC. Rebuttal testimony of witness Oliver, page 2, lines 1 through 2. AOBA's rebuttal only responds to staff and to OPC. Bruce Oliver did not respond to Pepco. Similarly, OPC's rebuttal from witness Stevens and Alvarez indicates on page 1, lines 16 through 18, that it responds also to staff witness Austin. No party in rebuttal rebutted positions previously taken by Pepco. As this case is about Pepco, clearly all arguments by all parties involve information provided or lack thereof by Pepco. Thus, there was no reason for Pepco to submit its surrebuttal testimony, but Pepco not only did so, but submitted surrebuttal testimony of 5 witnesses. Pepco filed rebuttal testimony in response to parties' direct on December 27, 2024, with the testimony of 7 witnesses, 1,200 pages of testimony and exhibits. On February 28, 2025, Pepco submitted surrebuttal by 5 witnesses, even though no party had addressed or responded to anything other than Pepco's direct prior to February 28. Pepco now wants a second bite at the apple, so it can now submit rejoinder to further respond to AOBA and OPC. AOBA has put a substantial effort into preparing for these hearings, and even though surrebuttal testimony was only filed within 5 days of this hearing, we've worked hard to address the company's unusual, very unusual filing of surrebuttal testimony. And I do echo exactly what Mr. Spivak said, in that it is highly unusual for the company to file surrebuttal and rejoinder. Now Pepco is seeking to further respond to the parties in a manner that will allow AOBA and other parties no opportunity to challenge their representation. If Pepco alleges that there is new information to which they absolutely need to respond, they should state the subject and the witness that will present the rejoinder, and the hearing should be delayed in order to give the parties reasonable time to prepare cross-examination and challenge the company's representations. AOBA's position is this: in this case, rejoinder is inappropriate and hearing should proceed as previously scheduled without rejoinder.
OPC agrees, and we do object to any rejoinder being offered today to the extent that it raises issues that could have been made earlier in this proceeding in the pre-filed written testimony. Ms. Curry mentioned that Pepco bears the burden of proof, and that's correct. But other parties to participate take on their own burdens when they challenge those presentations by the company. In this case, Pepco didn't fully present its case in direct. It waited until rebuttal to raise a lot of issues that it glossed over at best in its direct testimony. So, preventing Pepco from providing live rejoinder today would not deprive them of any due process right. They've had plenty of time to respond to the positions that other parties have taken. On the other hand, permitting Pepco to put on that testimony today through live rejoinder deprives OPC and other stakeholders of their due process rights to obtain evidence in time to review, and consult with their witnesses, and take discovery. So, at a minimum, we would ask the Commission to limit any live rejoinder to issues that could not have been raised earlier, and we would ask for each line of questioning to be preceded by a proffer of what information was provided to Pepco without them having an opportunity to respond.
Mr. Chair, staff does not join AOBA and OPC in their objection to the live rejoinder. As the company said, they do have a burden of proof here, but I do note again that it is very unusual for the company to both file Sir rebuttal and do live rejoinder.
So, what's your opinion about this sort of middle ground that the two of them have talked about?
I think if you are going to allow the live rejoinder, it is certainly appropriate to limit it very, very strictly to things that were said on Sir rebuttal.
Okay.
And, ideally, the restriction they've requested is probably not a bad idea as well.
I'm happy to respond. The staff counsel indicated that this is highly unusual. I actually have the dates that we filed Sir rebuttal in all of those cases that I mentioned. So, for example, in case number 9702, the company filed Sir rebuttal on February 23rd, 2024, and we also did live rejoinder. In case number 9655, the company filed Sir rebuttal on April 20th, 2021. We also did live rejoinder. Case number 9602, a historic test year. The company filed Sir rebuttal on May 16th, 2019. We also did live rejoinder. Case number 9443, another historic test year from 2017. The company filed Sir rebuttal on August 24th, 2017. We also did live rejoinder. Finally, case number 9418 from 2016. The company filed Sir rebuttal on September 1st, 2016, and we also did live rejoinder. So 5 cases going back 9 years, we have done this. This should not be a surprise to the parties. So I will have to object and push back to OPC and AOBA's claims that they need additional time. This has been a very, very long-standing practice, and they cannot say now that they have been caught off guard. To OPC's point, or perhaps it was AOBA, that said that we provided a lot of new testimony in our rebuttal. We were being responsive to the intervener's direct testimony. Throughout our rebuttal, we cite our responses, who we're responding to. We have every right to respond to rebuttal testimony. One other thing to add about that is during the time the company was working on our Sir rebuttal, or our rebuttal, the Commission issued an order in the BGE case asking BGE to supplement their testimony with prudency analyses. So in addition to properly responding to the parties intervener direct, we were also being responsive to the Commission's order. So one other thing to mention, in prior orders where the Commission has allowed live rejoinder, this statement has been in those orders. Pepco will be allowed to present live rejoinder testimony, limited to the other party's Sir rebuttal testimony at the evidentiary hearings. That's been language in Commission orders. That's the way we've handled it. We've limited it to the party's Sir rebuttal testimony. We've historically done that, and we would do the same thing that we've historically done in this case as well.
Your Honor, may I just briefly respond? There are 2 very key differences in this case. First, Pepco really waited for its rebuttal testimony to file its direct case. And second, No one filed rebuttal to Pepco. It was only OPC witnesses Alvarez and Stevens, Bruce Oliver, both of whom addressed witness Austin. There was no reason for Pepco to file surrebuttal testimony to witnesses that were not responding to them.
The only point I would like to make is that Ms. Curry has presented a lot of instances where live rejoinder was permitted under some circumstances in the past. But what we'd ask the commission to do today is examine the rationale for permitting it in this case. And in this case, Pepco should be required to show why live rejoinder is appropriate by pointing to issues raised in surrebuttal for the first time where they did not have an opportunity to respond. So it shouldn't even just be what was in the surrebuttal, it's what they could have responded to prior to that. Because frankly, this process is set up to be to proceed through pre-filed written testimony. The examination that takes place in a evidentiary hearing is intended to be cross-examination that cannot be provided any other way. So, providing Pepco an additional opportunity to present testimony that, for all I know, is going to be the first time we hear of it, is not fair, and it shouldn't be allowed in this case.
Again, Mr. Chair, I would say that it is fairly normal for a company to be allowed to do live rejoinder in a case. That I would grant. But I also note that in response to what Ms. Francis said, actually, given that Pepco's surrebuttal is responding to is not responding to anything that was directed at them, the appropriate remedy for that might be not to admit the surrebuttal, but then to allow live rejoinder.
If I could just respond to that, there was no limitation on us not filing surrebuttal, so we're completely within our rights to do that. And I have seen commission orders where it says surrebuttal is available to all parties, so it's not unusual for the company to file surrebuttal.
All right, absent anyone opposing, I think we're going to not allow live rejoinder in this proceeding because of the fact that you did file surrebuttal testimony. So, anyone have a? All right, okay. Go ahead.
If I may just, again, going back, this has been something we have done before, so it's a bit surprising that the commission is taking a changing course. May I inquire why the commission is changing course after doing this practice for 9 years?
Well, the difference in my mind is the fact that you did file surrebuttal testimony, and was alluded to by Mr. Ostlander. We try to limit the presentations to the written documents that we get, as opposed to, in a court proceeding where you're having live witnesses testifying to facts. And so you've gotten this extra round of testimony that you've put before us that we're going to listen to today. And so I guess I'm a little concerned about giving you an additional, boost to this testimony through live rejoinder.
But that's not unusual. As I mentioned, we have filed surrebuttal before and gotten live rejoinder. This is not unusual for us to do this. In fact, we have frequently filed surrebuttal as well as gotten live rejoinder. So there's been no difference in this process than what the company has done that would justify a change in policy here today. And that would be my concern, is that there's a deviation from a long-standing commission policy with no notice to the company, and it does impair our ability to make our case.
Your Honor, I don't think we're asking for a change in long-standing policy. We are applying the facts of what happened to this case only, and we are asking for the chairman to keep its ruling, and noting again that what's unusual is there was no rebuttal filed to Pepco. Big difference.
I just have one more point. There is new testimony in the surrebuttal that the parties had that we have not seen before. Without live rejoinder, we would not have the opportunity to respond to that new surrebuttal testimony.
All right, let me get back to Mr. Alshinder's. Your suggestion was,
So, my suggestion was, if the commission is going to permit it, they should, strictly limit it to issues that could not have been raised earlier. And we feel at this point that Pepco hasn't even made a proffer as to why they need the live rejoinder in the first place. So we would ask that the proffer come first, and then as the witness is answering questions, the company should be required to, point to a portion of the surrebuttal testimony that they're asking their witness to respond to. And to the extent that our witness is just rehashing arguments from rebuttal, that would be an instance where live rejoinder should not be permitted.
and Ms. Francis, is that acceptable to you?
I agree with that. They have to say what exactly is the new testimony that has not been presented before, that they have not been given an opportunity to present their testimony for something totally new. They have to say what it is, which witness will be discussing it in live rejoinder so that we can get prepared for it.
I think that's about as fair a resolution as you're going to get, Mr. Chairman.
Does that work?
We did plan on citing the exact places in the testimony where we do plan to do our questioning, and the parties can, raise an objection if they want.
Okay, that's what we'll do. So, all right. Anything else?
Yes, Your Honor. We have an issue with one of our witnesses having a medical emergency. Mr. Alvarez was originally scheduled to fly out and be here today. He's unable to do that, and we understand that he's under doctor's orders not to travel in the short term. So we would ask that the commission permit him to testify virtually in this case, because otherwise we believe we would need to reschedule for a date, hopefully next week, for him to appear in person.
Anybody have a problem with that?
The company does not.
Okay, all right, we'll do that. So.
Thank you, Your Honor.
Sure. Now, he can't travel, but he's still able to participate. He's not like...
That's correct, Your Honor. My understanding is that he's been advised not to fly.
Yeah, I understand. So, okay, that works. So. Anything else?
There is one more preliminary matter regarding appearances of witnesses and waivers of witnesses. We would ask that if the parties have no questions for company witness Blazunas, or if the commission does not have any questions for company witness Blazunas, that he be waived and excused.
Anybody?
AOBA has no questions for Peter Blazunas.
Staff also has no questions for Mr. Blazunas.
We don't have any questions for Mr. Blazunas.
Okay. Alrighty.
But I guess I would just like to get clarification from the commission that you don't have any questions for Mr. David Efron, because none of the other parties do.
No, I guess we...
What's that?
We should go down the witnesses and the letter and see if the commissioners have.
That's a great idea.
Yeah.
If you want to do that.
I would also ask the same for with regard to Mr. Hoppick.
The company has no questions for either OPC witness Efron or staff witness Hoppick.
AOBA either.
We don't have any questions for staff witness Hoppick.
And AOBA has no questions for staff witness Hoppick.
Okay, so at this point, we would be waiving...
Well, the commission might.
Right. Yeah, I would just go down the list and
Oh, I think parties have said they don't have any questions for Bruce Oliver. However, Mr. Oliver is available, will appear tomorrow or Friday at the commission's request. Just wanted to know if the commission had questions, and he will be available, or he is available.
Okay, all right. So at this point, we're waiving cross of company witness Blazunas. Is that how you say his name?
That's correct.
Okay. OPC witness Efron and staff witness Hoppick, correct?
Correct, Mr. Chair.
Okay, alrighty. And, I mean, I realize Mr. Oliver's local, so let's have him come. We may not ask him any questions, but, you know.
He'll be happy to.
But let's have him here, so, okay. So, anything else?
Nothing from the company.
nothing from OPC.
Nothing further from staff either.
Okay, all right.
Pepco calls Morgan O'Donnell to the stand.
Now, we just waived Luzunas, Efron, and Hoppick. Luzunas, Efron, and Hoppick. Good. What? Okay, let's tell the commission. Okay.
No.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Sure. It's Elizabeth Morgan Downs O'Donnell. My first name is Elizabeth. Last name is O'Donnell. My business address is 701 9th Street, Northwest, Washington, D.C. 20068.
Thank you.
Thank you.
Ms. O'Donnell, do you have before you a document entitled Rebuttal Testimony of Elizabeth Morgan Downs O'Donnell on behalf of Pepco?
Yes,
Was that testimony prepared by you or under your supervision and direction?
it was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you the same questions today under oath, would your answers be the same?
They would.
Your Honors, I would like to have the rebuttal testimony of Elizabeth Morgan Downs O'Donnell marked for identification as a Pepco Exhibit Number 1 and move that it be admitted into evidence.
Your Honor, if I may make a request, for exhibits that are entered in this proceeding, could we add an FR designation to the end, just to make it easier to sort through these exhibits as opposed to the ones that were filed in the base rate case in this proceeding?
And what would the FR stand for, Counsel?
Final reconciliation.
No objection to that. With that, I would rename it as Pepco Exhibit Number 1 FR and move that it be admitted into evidence.
No objection.
So marked, so admitted.
Ms. O'Donnell, do you have a document before you entitled Surrebuttal Testimony of Elizabeth Morgan Downs O'Donnell on behalf of the company?
I do.
Was that testimony prepared by you or under your supervision or direction?
It was.
Do you have any corrections or deletions to make to the testimony at this time?
I do not.
If I were to ask you the same questions today under oath, would your answers be the same?
Yes, they would.
Your Honors, I would like to have the surrebuttal testimony of Ms. Elizabeth Morgan Downs O'Donnell marked for identification as Pepco Exhibit Number 2-FR and move that it be admitted into evidence.
So marked, so admitted.
Thank you, Your Honors. I do have questions, live rejoinder questions for this witness. 2 questions for her.
Your Your Honor, could counsel please proffer what new information she is requesting of
I-
witness O'Donnell?
I have a cite to the testimony of specifically Mr. Alvarez that involved information we had not seen before. Specifically at pages 6 and lines 5 through 7, witness Alvarez states that we did not consider or adequately consider the customer perspective. That was an argument that we had not seen in prior intervener direct, and we will be addressing that. All right, Ms. O'Donnell. On page 6, lines 5 through 7, OPC witness Alvarez states that the customer perspective is not considered. How do you respond to that?
Well, I don't agree with that assertion. I think it's really important to take a step back and really look at how the company has considered its customers. During the pendency of the MYP, we've certainly provided the best reliability service to customers in the state of Maryland, and it is seen through our customer satisfaction surveys. For overall satisfaction, they've remained in the mid 80%, and then for reliability in the mid 90%. So I do want to factor in the fact that we're cognizant of our customers when we're considering these projects, and certainly in our operational performance. While we've performed all that for our customers, we have certainly been fiscally responsible. Mr. Alvarez insinuates that and is dismissive our ability to control our O&M costs below the rate of inflation in what was a very highly inflationary period. We've kept that below the rate of inflation, and I think it's misleading for Mr. Alvarez to make that statement. In addition, while we recognize that it is our responsibility to remain within the revenue requirement, we do need the flexibility to make decisions about that revenue requirement. And over the pendency of the MYP, we've managed our spending plans within 2% of the total revenue requirement over the MYP period. So it's important that we set a plan at the beginning of the MYP, but we need to have flexibility about that as we've gone through the case, given the COVID environment, the high inflation environment, et cetera.
My next question pertains to Livingston Road. This is a reference in OPC witnesses Stevens and Alvarez's testimony regarding interactions that the company had with the contractor. I'll ask the question. OPC witnesses, Ms. O'Donnell, OPC witnesses Stevens and Alvarez acknowledge at page 17, lines 14 through 17 of their surrebuttal testimony that while Pepco actively monitored the Livingston Road project status and appropriately identified deficiencies and slipping timelines to the contractor, active monitoring does not necessarily mean that Pepco adequately managed the contractor's performance. Do you agree?
I don't, but first I want to thank OPC for making the adjustment to their testimony to reflect that we were not seeking recovery of 50% of the project cost for Livingston Road, so thank you for making that adjustment in Sir rebuttal. I do want to acknowledge that, taking our feedback on that. We did manage the contractor appropriately. We monitored their progress. We reached back out to them when they were not meeting the expectations of the contract with respect to the battery. And when they failed to remediate the issues that we discovered through the course of the project, we canceled the project with the contractor. And in fact, the approximate 50% of the costs that we're seeking through other means, not through customers, is how we are holding them accountable for their inability to execute on that portion of the project. But I think it's important that this is a pilot, and we certainly are learning from these pilots and will not execute perfectly. But I don't think we want to disincentivize the company from looking at innovative ideas in which we can defer large distribution projects, as an example, from a battery storage project.
Thank you, Ms. O'Donnell, and I have no further questions for the witness. She is available for cross-examination.
Your Honor, I have no questions for Ms. O'Donnell.
I have a few questions for this witness, Your Honor. Good morning, Ms. O'Donnell.
Good morning.
So I'd just like to start with a brief follow-up question regarding your live rejoinder. So you mentioned customer surveys and how customers give the company favorable scores for reliability. Do you recall how Pepco is scored in terms of affordability on those surveys?
I don't, off the top of my head, I do not.
And you were a witness in the case 9702 proceeding?
I was. I filed paper testimony. I was not a witness at the hearings.
So I recall that those surveys came up in that proceeding, and the company scored lowest on affordability. Does that sound right to your recollection?
Honestly, I just don't know. Subject to check. We'd have to follow up, and we certainly could follow up on that.
Okay, so you're not aware of how your Pepco's customers view their rates, but you're aware of how they view reliability.
Objection, asked and answered.
No, she can respond.
I do know how they view reliability, and then I know the overall score as well, which factors in many different questions, is my understanding.
Okay, thank you.
Thank you.
So now I'd like to start with a few questions about Pepco and its relationship with the Exelon Corporation. On page 1 of your rebuttal testimony at lines 10 through 11, you note that Pepco is one of the regulated utility subsidiaries of Pepco Holdings LLC. Is that right?
That's right.
And Pepco Holdings LLC is a subsidiary of the Exelon Corporation. Is that correct?
That is correct.
And I'd like to ask you some questions about Exelon's fall and winter 2022 investor presentation. And I have a printout here. I have exhibits for everyone with the excerpt, but I also have a full copy of the presentation for council to review, if you'd like.
I assume I can see it too.
Yeah.
Hey, approach.
Thank you. Is it just one or fall 20 winter 2022? Is
Yeah.
it just one? Okay.
Yeah.
I have an extra, so.
Okay. And Your Honor, I'd like to mark this as OPC Exhibit 1 FR.
So marked.
Okay. So, Ms. O'Donnell, have you seen one of these presentations before?
Yes.
And are you familiar with what they generally report?
Yes.
Now, please turn to the first page of the excerpt. It should be numbered page 4 down in the bottom right.
Yes.
And this identifies all the utilities owned by Exelon, and it shows that Pepco is one such utility, correct?
It does, yes.
Now turn to the next page of the excerpt, and this should be page 15 of the presentation.
I see it.
Now the header for this slide is reaffirming our 6 to 8% earnings per share growth target from 2021 through 2025. Is that correct?
Yes, that's what it says.
So you're familiar with this growth target?
Yes, and I'm familiar with the slide.
Okay. And this growth target applied to the period that included the planning and execution of many of the capital investments contained in rate year 3 of Pepco's multi-year rate plan. Is that right?
Yes.
Okay, thank you. Now, I have another document that I'd like you to review. And this document is Exelon's annual financial report for the year ending on December 31, 2024, filed with the Securities and Exchange Commission. And if my co-counsel may approach, Your Honor.
Sure. Yep.
Okay.
That's fine. That's fine. Thank you.
And Your Honor, I'd like to mark this as OPC Exhibit 2FR.
So March.
Okay, let me know when you're ready, Ms. O'Donnell.
I am ready.
Okay, thank you. So if you go to the page numbered 325, you can see that this was signed by Exelon CEO Calvin G. Butler Jr. Do you see that?
Yes.
And then if you go to the next page, you can see that this was signed by Pepco CEO J. Tyler Anthony, as well as Pepco CFO David M. Bajos. Do you see that?
I do.
Now, please turn, the following pages, I'm not going to have you look at those, but they're certifications signed by Mr. Butler Jr., Mr. Anthony, and Mr. Bajos that the information provided in this 10K is true and accurate.
I do see that.
Okay. So if you could turn to the page numbered 143, should be the third page from the top in the document.
Yes.
This page discloses Pepco's statements of cash flows. And the highlighted line towards the bottom identifies the dividends paid on common stock. Do you see that?
Mm-hmm.
And would you agree that the document shows that Pepco paid $463 million in shareholder dividends in 2022, $252 million in shareholder dividends in 2023, and $359 million in dividends in 2024?
I'm going to object.
Sorry.
Council has not tied these presentations to Ms. O'Donnell's testimony.
Ms. O'Donnell's testimony discusses Pepco's business judgment and decision-making process, and Pepco's obligations to Exelon shareholders are a key component of that decision-making process, in addition to ensuring reliable service for customers.
I'll allow it. Go ahead.
Thank you.
Do you mind asking your question again?
Sure.
I'm sorry. Just want to make sure I captured it.
Sure. So you'd agree that the document here, this is the highlighted line, it shows that Pepco paid $463 million in shareholder dividends in 2022, $252 million in dividends in 2023, and $359 million in dividends in 2024.
I agree that that is what it says from a dividends perspective, but if you look at the line below it, that it says contributions from parent, which represents cash flows that Pepco received from the Exelon parent. It's right below it, just to make sure. Are you there? So you have to net those together to get the net figure of cash flows received by Pepco. And if you look at the history of Pepco over, I think, approximately the last 7 to 8 years, and you look at the net income, the dividends received by the parent, which is Exelon, and then dividends up to the parent, we've actually seen that Exelon has reinvested over 95% of its of the company's net income back into the company for investing. So I agree that those numbers are correct, but you have to look at it as a netting in terms of what's the net contribution that has come back to the company.
And could you turn to the following page, please?
Yes.
Could you identify the retained earnings balance as of December 31, 2024?
I think it's four. Are you referring to the 4.4 billion or?
The
I'm sorry.
retained earnings, it's the next column over. It should be 1.1 billion.
Sorry, I'm just trying to make sure I see where you're talking about.
Yeah, it should be the very last line in the chart.
Oh, you're the centered line.
Yes, that's
yes,
correct.
yes. Retained earnings of 1.1, and then it goes on to show the net shareholder equities that's received by the contributions of the parent.
Okay. And now if you could turn to, I guess, the second page in the document. This should be the page with the number 37 at the bottom.
Sorry. I'm there.
Okay, and this page, this document shows that Exelon is PHI's sole shareholder.
Well, Exelon, it's a subsidiary of Exelon. Exelon is the only issuer of shareholder debt. I mean, shareholder equity. Is that? I just want to make sure I understood your question.
Yeah. So if you see
Pepco doesn't issue debt equity itself. Only Exelon, the parent.
And so if you look at the line, there's a header that says Pepco, and then the line underneath that, it explains, as of January 31st, 2025, there were 100 outstanding shares of common stock, all of which were indirectly held by Exelon.
It's this.
37.
It's the second page of the document you're on.
It says 37 at the bottom.
Yeah.
Yeah, we went backwards. Sorry. Go ahead.
Okay, so you see the Pepco, there's a little Pepco header in bold.
Yes, I see
right?
that.
So underneath that, could you confirm that it says there were, as of January 31, 2025, there were 100 outstanding shares of common stock, all of which were indirectly held by Exelon?
That's what it says. Yes.
Okay, thank you. So I will move on from that. And now I'd like to ask you a couple questions regarding your testimony on prudence.
Okay.
And this is, so let's start with your rebuttal testimony. On page 11, you identify two foundational principles. And I'll lead you there.
I'm there.
And so the two foundational principles you identify are the information the utility knows or should have known at the time the decision was made, and whether the decision would have been made by a reasonable management team. Does that sound right?
Yes.
So I'd like to ask a few questions about this first principle. So please turn to page 16 of your rebuttal.
I'm there.
And here, starting, I think at question 29, you discuss the company's review process for capital and O&M projects. So capital projects, as you explain, over $1.5 million or with an identified risk, go through the Project Concurrence Committee review process, correct?
That's right.
And so to understand what the utility knew at the time it made its decision, what information would the commission need to look to?
Sorry. Do you mind asking that again?
So to understand what the utility knew at the time it made its decision for capital projects over 1.5 million or with an identified risk, what information would the commission need to look to?
Well, in a MYP proceeding, the commission has certainly the original spending plans that we provided in the direct filing. In addition, we've provided several PCC decks that have information through the course of a project that lays out the rationale for the project, the benefits for customers, the benefits, their environmental benefits. There's a variety of other benefits that are laid out in those PCC decks that we provided. They certainly could utilize those as an understanding of what we knew at the time that those projects were developed and decisions were made.
Now, for capital projects under $1.5 million, those are reviewed by a team of subject matter experts and approved at the vice president level. Is that correct?
Yes, I think it's at the category level of the respective vice president. Yes.
And so to understand what the utility knew at the time it made its decision on one of these projects, what information would the commission need to look to?
I think a lot of the programs that run through the lower threshold process are there are examples of programmatic programs, so I think certainly the commission will rely on regulations that approve some of that programmatic work. There's certainly the testimony we've provided in this proceeding for the details about those projects that the operational witness can talk to. In addition, I think we've provided some materials in terms of what the rationale was at the time as to why the project was processed and then how it proceeded.
Okay, and now turning to O&M spending, I think you explained that spending is based on a 5-year long-term plan and reviewed through management reviews, challenges, vetting sessions, and monthly budget meetings. Does that, your testimony has a number of lines on this. I'm just trying to summarize.
No, I understand. Yes, I certainly talk about the long-range planning process that looks at the 5-year plan from an O&M and a capital, and also financial statements and resulting financial metrics. That's a process that we hold every year. We do challenge significantly, and that's why you actually, from an O&M perspective, have seen our ability to contain the O&M at a level that is below inflation because of those challenges, as an example.
And so to understand what the utility knew at the time it made its decision, what information would the commission need to look to?
Again, similar to capital, there was plans that were filed with the commission in terms of the detailed plan, and then the subsequent filings that were made for annual information filings, and then certainly the testimony that we've provided in this proceeding.
And do any of those filings provide project level information on O&M spending?
These are probably questions you'd want to ask Mr. Vahos, but there's certainly detailed projections at various, either at FERC account, that you could ask Mr. Vahos about.
Okay. Now, would you agree with me that there's a number of phases in the development process for a capital and O&M project at Pepco?
Yes, particularly significant ones.
And throughout the project development process, there's a number of decision points that come up at the varying stages of the project's lifespan.
That's right. Different phases, different authorization points.
So even after a project has been approved and the work is commenced, is it correct that there are further reviews required if certain circumstances arise, such as a need to change a budget or a decision to cancel or delay a project?
Yes.
And so for the purposes of prudence review in this proceeding, what decision points should the commission focus on to assess the prudence of Pepco's capital and O&M investments?
I think it's fair to assess it at all points that are available in terms of the project. I mean, certainly, it's important that they deem it that it's in use, used and useful, and that it's actually providing service to customers. So that's first, the most important part. But second, obviously looking at the decks and the materials we provide in testimony as to various decisions as to why either a change in a budget was made or why we may have pivoted from one project to another due to emerging circumstances.
And for each project that's included in Pepco's reconciliation revenue requirement that was added to plant in rate year 3, does the company provide documentation for the decision made at all phases of the project's lifespan, or is it just limited to for projects above 1.5 million, the project incurrence slides?
I'm sorry, could you reframe your question?
Sure. Yeah, sorry, that was...
I just want to make sure I captured it.
Yeah, no, I appreciate that. So, you given your testimony that there's a number of different decision-making points throughout the development of a project, and all of those points are relevant for the commission to determine whether Pepco's the project was developed and executed in a prudent manner. Did you provide documentation for the decisions made at each of those decision points?
I don't know if we perfectly provided all decision points for all projects. I think what we provided was a lot of the projects that are significant in nature. But again, if there's specific questions to different projects, those would be best suited for the operational witnesses.
Okay, thank you. Now, let's turn to page 12 of your rebuttal.
Look at your email.
I'm sorry.
Sorry. So please
What page
turn-
did you say?
Page 12.
Okay.
And here on this page, you identify several business practices that you state align with the foundational principles that you identify earlier in your testimony. Is that right?
Yes.
And one of these principles, it's at line 15 through 17 on this page, refers to the company's internal review process, which includes evaluating the customer, social, and environmental benefits anticipated at the time a decision is made. Could you clarify how the term benefits is being used here?
So if you looked at a sample PCC deck, there are certain benefits for customers. As an example, there may be a reliability benefit to customers. There could be an environmental benefit. So we frequently look at equipment as an example, and I'm going to caveat I'm not an engineer and I'm not an expert in this space, but we certainly look at switching out materials or equipment that may be harmful to the environment as we've learned things about different equipment. So that could certainly be an example of a benefit.
And I noticed that you didn't mention affordability as a benefit. Is rate affordability not a consideration made as part of the company's internal review process?
The impact to customers is certainly assessed as a part of the as looking at projects, but I think it's more important to look at customer impacts from a holistic purview, and looking necessarily right at every single project could tell you the impact to a customer, but it's pretty important to look at it holistically in terms of all the investments in the portfolio of costs that we're providing, and we do certainly think about that and consider that as a part of our decision making.
And the last business practice that you identify here, I think it starts on line 22, at the very bottom of this page, is the company implementing a robust process to review expenditures before those expenditures are made to support a conclusion that a reasonable person would have made a similar decision. Is that right?
That's what it says, yes.
And is it correct that this practice excludes the review of expenditures made after Pepco approves the project and while the project's being implemented?
Sorry, could you just restate your question?
So this this business practice you identify here, does it exclude the review of expenditures made after Pepco approves a project and while the project is being implemented?
No, I think we've shown that we do continue to assess projects as we proceed along the way. Livingston Road is probably the best example. Is that what you're...
Well, that seems a little to conflict a little with your testimony that says the company implements a robust process to review expenditures before those expenditures are made.
Well, I think we do both. We
Okay.
assess initially, and then we have to continue to assess as we proceed, particularly with large projects.
Now, how does the company assess fiscal prudency and cost effectiveness once a project budget has been approved? Is that is there a regular review for capital project budgets? Is there a process for that, or is it the main consideration of costs does that come in developing the initial project budget?
I think we just take an initial look at it when we develop the project and for the approval. But I think, again, we have to continue to assess as we proceed with projects whether it's being executed effectively.
Okay. So I'd like to ask you about a DR response that you sponsored.
Okay.
And this is OPC data request 10, question number 6.
I think I have it, actually. Yeah. Thank you.
And Your Honor, I'd like to mark this as OPC Exhibit 3FR.
So marked.
Ms. O'Donnell, are you familiar with this response?
I am.
Okay. And I'm going to ask about subparts B and C. These questions ask for your views on benefit cost analysis, and particularly whether it is your view that a benefit cost analysis is insufficient for gauging project cost effectiveness and does not adequately weight the customer value derived from a project. And your response states that you do not necessarily agree with those views. And so I'd like you to clarify your response here. So would you agree that a benefit cost analysis can adequately weight the customer value derived from a particular project?
I think a benefit cost analysis certainly can be utilized as a part of a full portfolio of assessing a project's value. I just don't, I think what I'm saying here is that it's not one data point that you can look at. Certainly, I think it also depends on the type of project. So I think even the OPC witnesses have made statements around benefit cost analysis with respect to providing safe and reliable service, that it's not necessary, that there's examples of new business where a BCA may not be appropriate. I think it really depends on the project. For example, the EV smart charging program, we certainly put together a BCA test because it was new technology, and we felt that that was an important data point to assess a project before proceeding. But I think it's one data point, and it needs to be appropriately used for specific projects.
But within that data point, would a BCA adequately weight customer value derived from a project?
I think it's one data point. That you have to use as part of your toolbox, but it could be used to assess the customer benefit, but it may not be the only tool that can be used to assess a customer benefit. Sometimes there's non-quantifiable benefits that you can't include in a BCA.
So I'll take the answer to my initial question as no. Okay.
Objection.
Actually, I think she answered the question. So
Okay.
let's,
Okay, now I'd like to ask you about page 14 of your rebuttal testimony. And starting at line 4, you identify 3 parameters that Pepco uses to demonstrate prudence in this proceeding. The first is that capital projects must be used and useful, or O&M expenditures must be reasonably incurred in fulfilling the obligations of the utility. The second is projects must pass a reasonable business judgment decision process. And the third is that project costs are managed in a reasonable manner. Now, as you use it in your testimony, does the term used and useful mean serving customers?
I think of used and useful as in service and providing service to customers, yes.
And is it your testimony that any project that is serving customers is prudent?
I think generally yes, but there's certainly examples where that may not be the case, but I believe that they are rare.
Are you aware of any capital investments that Pepco has ever made and sought recovery for that did not serve customers?
Yes, we've sought canceled capital projects in the past and sought recovery, and I believe have been successful in getting recovery because of the circumstances in which we had to cancel that project, as an example.
But were those projects prudent?
The commission deemed them prudent because they gave us recovery of it, so I think I could think it'd be fair to say they were prudent.
Okay. Now the second parameter, projects must pass a reasonable business judgment decision process. this business judgment decision process, does this refer to the various processes that we discussed earlier today?
Yeah, and certainly just from our experience as, in the utility, obviously there's judgment that we use in terms of assessing whether a project should move forward or not.
And so, if I read your testimony correctly here, as long as a project is, required to go through some sort of business judgment decision process, then it could be prudent.
Yes.
Okay. And all the projects the company pursues are subject to some sort of business judgment decision process. Is that correct?
Yes.
So if I read the first two parameters here, is it the first being, the project has to be used and useful. So is it your testimony that any project that is serving customers that went through one of the company's project review process is prudent?
Well, I think there are multiple factors, right? So you're looking at one in isolation, so I think you have to look at them all together. So maybe ask your question again.
Sure. So I'm looking at 2 out of the 3 factors.
Yes.
The first factor is that for a project to be prudent, it must be used and useful, and you define that as serving customers, and just in the testimony today. So a project that is serving customers that also went through the company's project review process, under your 3 parameters to demonstrate prudence here, any project that's serving customers went through that process, so any project would be prudent.
Under this framework, yes, but I think there's a third component that talks about that the costs were managed.
I'm about to ask about that.
Okay. We're executed on in a reasonable manner.
Yeah. And so I guess, so really, if every project that is currently serving customers, since it went through Pepco's decision-making process, from the company's perspective, it's prudent. The real, from the company's perspective, is the only issue, the only factor at issue in this proceeding project cost management?
I think that's oversimplifying it, so I don't think that's necessarily the case.
I'm just using the formula you provided, Ms. O'Donnell.
Okay.
Now, what I find noticeably absent in the 3 parameters that you identify is any discussion about whether a project is necessary to customers or provides value to customers that justify cost recovery. Is it Pepco's position that the Commission's prudence review in this proceeding should ignore how a project serves customers and the value it provides?
No, I don't think so. I think that's probably part of the used and useful in providing service to customers. That certainly there's a value to customers when we're assessing a project.
But the value to customers, if that falls under the used and useful banner and parameter, that necessarily divorces it from the cost component. Is that correct?
Is that a question?
Yeah, I
Sorry.
think that's a comma, right?
I don't think we're saying that costs are not important. I think as I mentioned, that we manage the costs in a reasonable manner and that there is a customer value to the project. And so if you think back to the PCC decks we were talking about, we certainly take into account the benefits to customers and other aspects. And while this is a framework for prudency, I don't think it is all done in isolation.
Okay. I'd like to ask a couple questions about your rebuttal.
Okay.
And so if you could turn to page 5, on that page, you answer a question about whether there is precedent for the company to justify every expenditure it seeks recovery of.
Yes.
And starting at line 7 in your answer, you say there is not, and that you're unaware of any instances in which the Commission has previously required utilities, in traditional rate cases, to justify every expenditure in their direct testimony. And you also note that the review of historical information effectively makes this proceeding comparable to a traditional rate case. This is not a traditional rate case proceeding, correct?
No, it's not. It's an MYP proceeding. But I think you can look at it similarly in terms of we are looking backwards at historic information. But the parties have actually, in this proceeding, had the advantage of knowing those costs in advance. So, but it is looking backwards in terms of actual costs that the companies incurred in comparison to what was approved in the original filing.
And you note that all the information that is being reviewed in this proceeding is historical information. Was all the information provided in the company's rebuttal testimony known by the company at the time it filed its reconciliation request?
Ask that again.
So,
Sorry.
all the information the historical information you point to, all of that information, was that available to the company at the time that it filed its initial reconciliation revenue requirement request and direct testimony?
Could you be more specific about the information? I mean, do you mean, is there some aspect of the rebuttal or the testimony we filed?
So, so on this line 7 to 8, you state all the information that is being reviewed in this proceeding is historical information. So, all of the information that you reference in your testimony, was that information available to the company when it filed its direct testimony?
I believe it's a general question. So, but yes, I think generally the majority of the information we did know in terms of actuals. We certainly had PCC decks we provided, which we provided during the course of the proceeding. But yes, there was. I would say generally yes.
Were there any impediments to the company from providing all of this historical information with its direct testimony?
No, I think the one thing I'll say is that I think we're learning through this MYP process. I think when we filed our direct case with the information per the order, the rules of the road in terms of the MYP process, but certainly as we've monitored BGE's reconciliation and other things, we've recognized that we've needed to give information. And that's how we were trying to be responsive to the parties in the rebuttal and also be responsive to the direct testimony filed by the interveners.
But to ask my question again, were there any impediments preventing the company from providing all that information?
I don't think impediment.
Objection. Counsel has not, he's referring to a site in Ms. O'Donnell's testimony, but these questions aren't specifically related to the citation that he's identified. So I'm objecting on the basis of relevance.
If I may respond, Your Honor.
It's relevant, so she can provide whatever answer she can provide.
So I'll repeat my question again. Were there any impediments preventing the company from providing all the historical information that you reference in your testimony?
I don't think there was an impediment, but again, I think we provided more information in rebuttal in response to the testimony filed by the interveners and also based on BG&E's experience in their final reconciliation as well.
And now your title with the company, you're the Vice President of Regulatory Policy and Strategy, is that right?
Yes, that's right.
So given that there were no impediments preventing the company from providing all this historical information, was the decision to provide all of the information in rebuttal a strategic decision?
It was not a strategic decision. It was a decision in response to the parties' requests and the points that they made in their direct testimony.
Okay, I think that's the last question I have for you. Your Honor, I'd like to enter OPC Exhibits 1FR, 2FR, and 3FR into the record.
I object to 1FR and 2FR. This was the investor presentation and then the 10K form. Counsel hadn't adequately established the relevance of these two documents to the witness's testimony. And the FR1 investor meetings presentation appears to be an Exelon document.
But you're part of Exelon.
We are, but Exelon's not seeking cost recovery for rate year 3. of the MYP in this case.
I'm gonna admit it. So FR, 1 FR, 2 FR, 3 FR are admitted. So Prince George's County.
No questions, Your Honor. Thank you.
Staff.
We have just a couple of follow-up questions from what Mr. Samatino asked. Good, I guess, still morning,
Yes.
Mr. O'Donnell. At one point in your testimony with regard to programmatic projects, you said, remarked that regulations approve some of that programmatic work. And I'm finding it difficult to see how regulations could approve anything. I mean, I can see that they would require you to do certain things, but approval is strange. Can you
Sure,
elaborate
I
on
can
what you mean
clarify
by
that. I think what I meant is that there's certainly COMAR regulations that will drive us to a decision to do certain programmatic work. I'm not suggesting that it is a pre-approval by the commission to spend those dollars.
Okay, thank you. The second thing is you had some cross-examination discussion on what the commission should be looking at in assessing the prudence of the company's projects. Do you recall that?
Yes.
Okay. Now, that's for each project, a certain amount of paper involved, I guess. Is that correct?
Yes, and certainly meetings and analysis and decisions that are made. Is that in terms of the PCC process? Is that what you're referring to, or?
Generally, in terms of the company's approval process for the various projects that it is going to go forward with.
It does involve a lot of decks.
Okay. And are there other forms of written documentation of that process that the company generally has?
I think you'd probably want to ask one of the operational witnesses, but my understanding is generally the PowerPoint decks that you reviewed as a part of our rebuttal.
Okay. Let me ask you this. Does the company generally provide that information as part of its direct testimony filings in a rate case, whether it's an MRP case or a historical test year case?
I'm working off of memory here, subject to check, but in our most recent MYP, and I think even the MYP before, I believe we provided a substantial amount of PCC decks either as a part of the direct testimony or in voluntary discovery. Or through discovery that followed throughout the proceeding as well.
That was kind of where I was going with that. A lot of the time that information is not necessarily provided to the commission in the company's filings, but is provided to the parties in response to discovery. Is that correct?
Yes, I think the one thing I'd want to make clear is I thought in 9702, I thought we provided that in direct testimony, but we'd have to follow up and clarify that.
Okay. All right, thank you. I just wanted to get clarification on those.
Thank you.
Is that it?
That's all I've got.
Redirect.
Ms. O'Donnell, going to OPC Exhibit 1FR, this is the investor presentation. The first page that is titled Reaffirming Our 6 to 8% EPS Growth. My question is there a benefit to Pepco customers as a result of a strong financial performance?
Certainly, it's important for the utility to have financial strength with respect to both the debt and the equity markets, because ultimately customers do pay for the cost of issuing debt or equity, and so for us to get capital on reasonable terms, it certainly benefits customers either through interest rates or equity.
If you recall the line of questioning from OPC counsel around affordability and whether the company has considered affordability as a benefit, what programs does the company offer to assist customers in paying their bills, if you know?
We certainly have programs such as budget billing, but there's also other programs that are outside of the company in terms of LIHEAP and programs in which we can provide energy assistance support that we also support and execute on behalf of the federal and the state funding. But in addition, we have budget billing, we have installment programs. We hold energy assistance days with our customers to provide them with the information necessary for them to achieve or receive energy assistance, to name a few.
And one final question. Do you recall OPC Council's questionings regarding was there any impediments in presented to the company in filing their rebuttal testimony?
Yes.
My question is, was the information that the company provided in rebuttal new to the parties, or put another way, had the parties seen the information before that we put in this case?
Yes, I think that I state that in my testimony as well, that this was information that had been provided during the pendency of the case.
Thank you. I have no further questions.
Okay, questions from the Commissioner. Commissioner Fleshman.
Good morning, Mrs. Donald.
Good morning.
Turning to your rebuttal testimony, page 3, starting on line 3, you state that your rebuttal testimony is intended to support the company's demonstration of prudence. So everything that we are dealing with today, in terms of sort of providing the 30.6 million under recovery, that's related to prudence, and so you're seeking recovery based on a determination, or your argument that everything that you've spent for recovery is prudent, but that you needed an additional 30 million because you under recovered.
Yes, I think in terms of the request in the proceeding, the 30.6 million represents an under recovery, but we do, through the variety of testimonies provided by the company, believe that those are prudently incurred, particularly since about half of the ask was for non-controllable reasons, vis-a-vis storms and pension costs, as an example.
Okay, but in terms of what you're asking for recovery for, that recovery is for all spend that you are arguing is prudent.
Yes.
Okay. And you've reviewed the testimony of the other witnesses as
Yes.
sort of the, okay. So, and in trying to sort of get a handle on sort of what the company spent, I looked to witness Lemming's chart that he put together. It seemed like it was the only place where I could sort of go to and have sort of a list of projects. So if I could ask you some questions off of that. So this is the RTLR-2, which I had my assistant blow up because I can't possibly read this. No reflection on you guys, what you're sort of putting together. But I wonder if you can get that chart out.
If someone could
Yeah,
give
I was
me
just
that, that'd
about
be
to
great.
offer if I
don't
could
have it
get
in my binder.
Please.
a copy for the witness.
And I'm assuming as you're getting this, that this is the one chart. I mean, I sort of went through the testimony, and it seems like this is the one place where everything is. Is that?
Let me look at it first,
Please.
and then I'll answer your question.
Okay.
Oh, yeah, this is a doozy. So this represents the actual plant additions for the capital projects that occurred during rate year 3.
Okay. So this would not include the O&M. So this
Correct.
would just be okay. And this occurred. These were the plant. This was the plant spend in rate year 3, or is this some of the? Does some of this reflect spend for other projects for other years?
Well, this represents the spend, the capital spend that was closed into plant during the pendency of rate year 3. However, there is capital expenditures. So let's say you have a multi-year project that takes 3 years,
Right.
and then it ultimately goes into service during rate year 3. That would represent all the spend to date associated with that project closed into service that's used and useful in providing service to customers.
Okay, so in going back to your definition, the parameters that Pepco uses in making a prudency argument, this all reflects used and useful.
Yes.
Okay.
And so does the O&M as well.
But the O&M is not on
That's
not on this
correct.
chart.
That's
Okay.
right.
Okay, so so all of these are reflected in the testimony of others today, or tomorrow, whenever we get to the
Yes,
testimony.
and
Okay.
what we've tried to do is give you a witness associated with each project in that column to the left of the dollars.
Okay, so is there, other than O&M, is there anything else that, that is being presented in testimony today or tomorrow, that is, you argue is prudent, that's not in this list?
I would say yes, those are the primary components, but as you know, the revenue requirement makes up and rate base make up many components, such as accumulated depreciation. But I think in terms of prudency, yes, I think these are the items to focus on.
Right, but, and then these are for the projects that went in service. So the projects that didn't go in service, that you're still asking for cost recovery, they're not going to be, like the battery storage, that's not going to be reflected in this.
Yes, so White Flint is probably the best example I can think of. We're certainly, we are spending money on the White Flint project, but you will not necessarily see that here because it's not been closed into service or planned service.
So, and then for, so you have a list of what look like positive expenditures, and then you have a list of spend that's in parentheses. So what would that be?
That I would have you ask witness Lemming
Okay.
to talk about the specific projects.
Okay. And then the final number, the 247 million.
Yes.
Okay. So that's the total span that is now placed in service. Of the 30 million, 30.6 million that's under recovered, what part of the 30 million is for plant? So it's, what is for capital?
I don't know the answer to that, but Mr. Lemming could answer that. I think it's probably a mix of things in terms of rate base. It may not be just plant, but it could be like the plant if you're looking at rate base.
Okay. Okay. So this
He
247.
can give you a breakdown, like a general breakdown of like what the 30.6 million represents.
Right. So the 247 million would reflect some aspect of that would then be an overspend, not sort of not accusing you of overspending, but it would be an overspend of what you had forecasted.
It would represent that we had a set amount of plant ads as a part of the commission's approval.
Okay.
And then a comparison, not that this number represents that, but then the 30.6 or a subset of that 30.6 million represents the plant additions that were above what was approved as a part of the commission's original order.
Okay. And then table 2, there are a whole bunch of projects listed here with a 0 value. What are these?
That I would ask Mr. Lemming because he knows the details of what makes up that listing.
Okay. That's all I have.
Okay,
Thanks.
thank you.
Commissioner Richard.
Thank you, Mr. Chair. Thank you, Ms. O'Donnell.
Good morning.
Good morning.
Well,
actually,
not
morning.
anymore.
It's now time for lunch.
It's lunchtime.
All right. Yeah, thank you. So your role here today is you're the I guess the big picture company executive role. Is that correct? The decision making and just giving those kind of insights into the request today. Is that a good way to describe your
I would
role
say
today?
I'm the witness that represents sort of the framework and the policy around prudence. I'm certainly not the only decision maker.
Recognize
Not
that.
yet.
But hopefully you can give you're here to give us some insights as to how these decisions are made.
Yes.
We started today just talking about how you look at the voice of the customer, and you did talk about the reliability is very important, and I think I did hear you say that affordability is also considered as well.
Yes.
Is that correct?
Yes.
I guess what I want to get to is how does that go into the decision making process? I assume that you said you weren't quite aware of what the survey said, but are you, whenever we get a CAD complaint here, does that information flow through you, or I know the company somewhere is informed about those CAD complaints, but are you and are senior executives aware of those complaints?
I'm generally made aware of complaints. I may not know the nuances or details of specific complaints, but I do understand that customers have challenges, particularly right now, with all components of the bill. And so we do recognize that, and we are continuing to try to find ways to support customers while also continuing to provide them service.
Okay, and so you're aware then the nature of these complaints, that over the last year, even more, they've been increasingly around, just they're concerned about the cost of service, the rates, the fact that they believe it's becoming really a burden and unaffordable.
I'm aware of the sentiment currently
Okay.
around bills, and certainly the bill pressure that, particularly on the supply side of the bill, that customers are starting to experience. But certainly, I think they don't see it that way. They see a total bill, which I understand. And so, yes, I'm very aware in subsets of our territory as well, where customers are feeling the pressure, and also understand that while we've tried to manage the inflationary pressure through our O&M and through our capital, but we understand customers are experiencing that. Obviously, price of eggs is a thing that people are talking about, and so I know that there's cost pressures in not just the electric bill, but certainly in other aspects of their household income.
But obviously,
Yes.
I'm just interested to know from your decision-making process inside the company, how the customer voice, obviously you're hearing very loud and clear that reliability is important, but it seems that the affordability, and I guess we were talking a little about this chart here. So it's clear that when you're addressing affordability, or I'm sorry, reliability, that's also good for the shareholder. And so that's a good incentive to try to meet that reliability. But in the decision-making process, how does affordability, how does that go into the decision-making process and get reflected, in an equal manner? Is there a company executive that provides that direction, or looks at the capital expenditures and various expenditures and says, hey, we're going to have some problem with affordability if we go down this route?
Yeah, I think it's almost inherent in what we do. So O&M is the best example. And so I think even in our initial filing with the commission, we talked about keeping O&M at a very low growth rate, which is particularly impactful because O&M is dollar for dollar for customers. So, $10 million of O&M is a $10 million impact to the bill. So that's definitely been a goal of ours, even under the pressures of the inflation environment over the last couple of years. That's been a focus of ours because we do understand that that's important, to keep that growth rate down for our customers, and we've been successful in doing that. I think there's other aspects that we're looking at. Certainly, we're supportive of the low-income discount rate and the mechanisms and the open proceeding as to other ways that we can support customers. So I think I like to look at it more holistically and globally as opposed to maybe not necessarily specifically, but it is something we do consider. It's in the back of our minds or in the front of our minds now, obviously. Yeah, it is. And so we have to make sure that we're cognizant of when we're assessing projects.
Okay, and we talked a little bit about that there are these programs, and that's great that you get out there and try to make sure people are aware. But that's not something that the company is providing support for directly. I mean, these are a lot of state programs, outside programs. Shareholders don't necessarily bear the burden of these programs, do they?
They don't in terms of our enablement of LIHEAP, as an example. Like today, we're actually at Capitol Hill. It's LIHEAP Day on Capitol Hill, and so we're there obviously advocating for customers to make sure that they can get those fundings. There's other ways that we support customers through a lot of the tools I talked about, like budget billing, installment plans.
Yeah, I hear
Yeah,
the ad.
no,
When I'm driving,
But
I hear
you're
all
right.
the-
We enable it. It's certainly it's federal and state dollars that we're utilizing for that type of assistance.
Okay, so when you're looking at these, expenditures, particularly with the capital expenditures, and you're aware that the commission's been very concerned about that in the last couple of orders. I mean, we specifically make this into question. Isn't it true? In the MYP, Pepco came in for a certain amount of capital spend, and the commission reduced that spend.
They reduced the revenue requirement that we requested, yes.
Yeah.
And said to us that we needed to, that was the revenue requirement. And if we chose to manage outside of that revenue requirement, that we certainly would need to come to the commission and show prudence and explain why we had done that.
Yeah, but isn't again when in the orders, and this is both in the you're not the pilot company, but also you were directed to look at the pilot company and their orders as well. But that has been, I think, a consistent theme. I would argue that cost was important. It was important to consider the amount and the impact that would ultimately be borne by the customer. And specifically, I would point out that you were told that okay, we are reducing the revenue requirement specifically to I guess lessen these burdens on the companies. So again, in the decision-making process, given that you're having a lot of concern expressed directly by the customer, which you say you listen to, the commission has said to reduce and again work within your budget. How is that being factored into the decision-making process, and why are we here with such a large increase? I mean, again, I know some of it is from storms and from other things that were outside the control, but a lot of it wasn't. It was initiation of new programs. It was overspend on current programs.
Yeah, and I think certainly as we progress through the hearings, you'll hear from our company witnesses as to the rationale as to why we had to spend we chose to spend money on certain programs. I think there's also tools at the commission's disposal to mitigate this prospective increase. So, for example, we're going to recover it over 1 year. That's what we proposed, and that would go into effect in 2026 after we've gotten through the other two reconciliations. The commission, if you were concerned about the bill impact, which I think is approximately $2.70, we could spread it over 2 years. So I think there are tools that we can use to address the affordability, but I do agree that we do need to exhibit to you and the rest of the commission that why we chose to spend those dollars and that there and the rationale associated with that. And I hear you.
Commissioner Suchman started to get into some of that detail, and we're looking forward to getting into
Yep.
that and really understanding the specific, maybe program by program prudence. Why did you initiate a new program knowing you were already over budget, and,
Right.
and why did you go over budget, and that type of thing? We can get into it. It just I'm trying to get back to just the overall prudence of not listening to your customers, and really it doesn't seem like you've totally listened to the direction of the commission either in how we've set budgets for you for these capital spend, yet you've chosen to go over those budgets, or not even seemingly, it doesn't seem like you look for savings anywhere else in the company. And so now we're kind of in this position. It's great that we have like customer support programs, but the money's been spent, and what I understand is you want it. You think you are entitled to that money that was over and above what the commission authorized in the order, and beyond what was authorized.
Yeah, and I think what the witnesses will talk about is there were things that we did, there were capital projects or things that we overspent on, but there were ways we did offset it by deferring work in other areas. So I would like, obviously, for you to hear the opportunity from the witnesses as to how we manage the overall budget as well,
Okay,
with that in mind.
Yeah, and that's what we're here. We want to hear the full record. But I just thought for your part of this is just trying to understand the decision-making process at the very beginning, where the controls are. Again, we see where some of the incentives are for some of the decisions made by the company. I'm just concerned that maybe there's not that same type of control, attention, sensitivity to the affordability side. And, and that may be just an inherent flaw of MYPs, that even if the commission provides specific, guidance, somehow you're here, the money's already been spent, and, we're listening to now why we should consider providing the shortfall.
Understood, and I think, well, the witness will talk about this, but half of the request is approximately associated with things were out of our control. But if you look over the MYP, and look, I recognize that $31 million is a lot of money, but we've really tried to manage within that budget. In fact, over the entire course of the MYP, it represents between 1% and 2% of the total revenue requirement. That's the $31 million does. Represents 1% to 2% of the total revenue requirement. So I'm not saying that to say it's not impactful, but we really have tried to do our best to manage within those bounds. But we've had things that occurred that, such as higher contracting costs, higher materials because of inflationary pressures, and then certainly things we had to restore power during storms, and we had some market impacts from pension as well.
And understand that, and I think
We do take it seriously, though. It's not. Again, I know 31 million is a lot, but if you look at it from a big picture, we really tried to stay within the bounds of the MYP.
Okay.
Approved.
We have to look at this as you like holistically in the aggregate. This is an important part of the customer bill, and you're aware that other parts of the bill are going up as well.
Yes.
And so, we can't just this is just our part, so we
don't.
can't-
That's
we
I
can't
didn't.
take that into consideration.
Please don't take that as what I said.
So,
but,
so anyway,
yeah.
we have to look at the big picture, and also just as far as last kind of question really is, what the as the company Exelon really wanted to have these MYPs, and so we're in this pilot. So we tried to set it up. It was my understanding, really, when we were trying to come up with the right formula here, actually not formula rates, but formula for what a MYP should look like, is really to find that balance. And the off ramp, I believe, was intended to be the primary tool if a company was really in distress or out of control of certain elements. That was I guess the mechanism. And really, reconciliation was something there to protect the customer from, overspend or underspending and just kind of pocketing the funds. And so there was supposed to be a rate of return on that overspend. What happened? Where did we go astray? Because even if you look at the BGE first order, I mean, it really talks at the very end about we will have a reconciliation process, and if there's an underspend, then there will be a true up for customers. It didn't talk at all about a true up for the utility. So where did the thinking change somehow that there was going to be this process for such a significant reconciliation for collection of revenue?
Well, my understanding and recollection from the order is that the process was there'd be a final reconciliation, which is where we are in this proceeding, and that reconciliation would be to assess the under or the over recovery based on the comparison to what was approved. Certainly, we've had lots of discussions in the lessons learned proceeding about ways that we may think are better. I know the company has proposed an earnings sharing mechanism that we think may better incentivize the company to control its costs.
Yeah.
So.
Okay. Well, again, it's just we are in a pilot. This is an area that I'm concerned is a fatal flaw to how we've carried out this pilot. But again, the last line of that is, additionally, of the BGE order, is that additionally there will be a reconciliation process and prudency review at the conclusion of the MRP, where the difference between the forecasted and actual amount will be evaluated, and any amounts owed to the customer will be refunded with carrying charges. So we didn't really talk about, again, this being a mechanism necessarily for for the company, and that's where it does go back to the what is the thinking when we're in a situation where there's this overspend or
Yeah, and I think there was the original order, obviously, that talked about the rules of the MYP prior to the BG filing. I think that's where you would find the details around the reconciliation process. I don't know BG's order in and out, but but I think that we covered that in the sort of the framework before the MYPs
And
are filed. Yeah.
I went and read a whole bunch of that before
Yeah.
for this hearing, and again, I would stand by that. I don't think it was intended to to be a process for having these types of massive sudden reconciliation process. So that's a concern to me. But anyway, I'll look forward to getting into the detail. We'll hear from the other witnesses today.
All right,
So
thank
thank
you.
you very much for your testimony.
Thank you.
Commissioner Burby.
Thank you, Mr. Chairman. Ms. O'Donnell.
Good afternoon.
Good afternoon, yeah. So just very quickly, the OPC is making the argument that Exelon's profits seem to be very, very good. So let me just, from a policy standpoint, do you think that's relevant to Pepco's rate making? What the parent company does? Is that relevant?
Well, I think that where it becomes relevant is that the parent is sort of the overarching umbrella, so they are issuing equity, and so there's certainly that aspect of it from a financial health perspective. But I think the focus should be on the utility itself, which is providing service. In fact, we're ring fenced from Exelon for a variety of reasons from the merger to protect us from sort of that risk.
I'm not familiar with that. Describe that to
The
me.
ring fencing
Yeah,
mechanism,
I'm not-
actually. I'm going to probably defer that to the CFO.
Okay. All right,
But
then
that
I'll-
became out of the merger. It's
I remember hearing about
yeah,
it.
it's
but
protections.
I wasn't on the relevant committee at the time. So.
Yeah, it came out of the merger, and so it's essentially a mechanism to protect the company from some of the risk associated with being part of a wider organization.
Okay, and on the second submittal of OPC, on their page 37, I noticed that the Exelon Corporation's 5-year performance is substantially under the S&P Utility Index. So that would seem to indicate that Commission's doing a good job limiting your profits, huh? You don't have to answer that. Thank you, Mr. Chairman.
Thank you.
So, Pepco made some changes to the billing, collection, and termination policies in response to the concern about increased bills. And I guess what I would want to find out was the motivation to make those changes in the policies over this winter heating period based on complaints that the company got, what I've been describing as fan mail that we get about the increased bills, or was it the attention by governmental authorities and press attention to this whole issue of energy affordability?
Just so I'm clear, you're talking about the measures we have taken in February and March to extend repayment and
those
not
actions,
issue.
right.
Yes, I think it was a recognition of a very cold winter, and that certainly there were rate impacts, such as in power and some other items that we were certainly cognizant of, and we were understanding that customers were dealing with some hardship, and so this was our one tool to help mitigate that temporarily.
But was it in response to complaints from customers about the bills being too high, or is it more related to just the news about the bills?
Well, there were complaints. There were significant complaints, particularly in the Delmarva Power territory. So absolutely, it was in response to what we were hearing from customers.
Okay, that's all I got. All right, so why don't we break for lunch and come back at 1 or 1:30?
You tell me. How about 1:15?
All right, 1:15. Yeah, we'll come back at 1:15. So just let people know we are going to be ending at 5 today. So, all right.
So thank you for the option out.